I think this is a good little button to put on this point, that when the other attorney is present, you should probably bring in your own, because of gamesmanship like this, that they're willing to try to dangle in front of the other attorney. They're trying to game the other attorney to draw it out. Imagine what they're going to do to a non-attorney.
Oh yeah, and we see this all the time. I'm Luke Carlson, and for almost 2 decades, my law firm, L.S. Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hello and welcome back to Bad HOA. It's been a while. Marty, good to see you.
You as well. I'm excited to be back. It's been the lights were brighter today. Like wow, lights always this bright?
Well, you and I have been deep in the trenches, and I think working very hard on some very exciting projects.
I wish we could, because some of the stuff that we have going on is so exciting. I wish we could disclose it, because I'm a bit eager and having a hard time keeping it to myself.
Yeah, same. We had such a good cadence with the show, and then you and I think both really aligned on what season 3 is going to look like, and we sort of have been down a rabbit hole with season 3, getting ready for season 3. Now we're on season 2, but season 3 is going to be groundbreaking.
It is one of the most ambitious projects that we've worked on, and has taken a ton of time and effort to help facilitate it. So, but I think it's really going to be worth it. It's definitely something that no one else has done in the space. So I'm excited to see how it all comes together. I'm excited for people to hear it and see what they think. Speaking of the way that people think, I was blown away with our time off. The amount of, shall we call it, fan mail?
Yes.
Like that we've gotten.
I was very humbled by it. When you see it though, to me, it says, hey, we're doing the right thing. We're empowering people. It's working. And they're so kind to write to us.
It's something, it happens so often. It's like, oh, I watch your podcast and I solve my dispute. And you're like, wow, like you do this and you sit in this chair and you think of like, yeah, this is great. But repeatedly it shows up, I was able to solve my HOA dispute. And it's like, when it comes full circle like that, it's so rewarding to hear on the other side. But I was blown away just with this bit of hiatus while we're working on season 3, that the amount that we received was humbling.
Yeah, very humbling. And so, at the end of the day, it's really, it reflects the community that has been built.
Yeah.
We planted the seed for it, but I got to give kudos to the community that they really took it, ran with it, and it's become such a positive, really a positive space in a very, I would say, otherwise dark and depressing space. When people talk about bad HOAs, it doesn't give you the warm and fuzzies.
True.
Instead though, you build this platform, you build a situation where other homeowners, they don't feel defeated.
Yeah.
They're feeling empowered. They're sharing strategies. They're sharing tactics. And, what we do on this podcast is we try to provide as much information and empowerment tools as possible, but it's really the community who's taking that information and pushing it to the next level.
Well, I think that was always the vision for our subreddit. Was we saw so many, for people that don't know why we did the subreddit, we saw so many subs that would complain,
right?
Which is funny. I mean, we some of those subreddits are unbelievable. Some of them are hysterical. Some are extraordinarily infuriating.
Yes.
But it was there because people just felt like they needed a sounding board to be able to put it out in the universe and people hear them out. And there is such a great place for that. But the need that we saw was, this is great. People are putting it out there. But what about on the other side? How do you solve it? There's no solution.
What's the solution, right?
Right.
You have the other subreddits, which is more venom letting or spitting venom, right? Because they're furious, and I get that, and that space is, I applaud that space as well. You know what I mean?
We go through it. It's interesting. I mean, we've had segments on our show just talking about people like spewing venom.
Yes, but the missing piece in my mind has always been, okay, you can complain, but be proactive, do something about it.
Yeah.
Be solution focused.
Yeah.
And so by setting up the subreddit Bad HOA, we wanted to lay that foundation, create a platform, and provide tools, at least some initial tools, frameworks, way of thinking about these things that a homeowner can go to and say, you know what, I have this problem and I've used X, Y, and Z.
Yeah.
And then you have some other homeowner who's maybe a little bit further down that warpath who says, hey, I would modify that a little bit.
Right. Well, it's really neat to be able to put some of our episodes up there, and we put it about CC&R violations, and they said, you know what's worked really well for me is this. So they've supplemented some of the stuff that we've put out and made it stronger.
Yeah.
Because they were saying this was highly effective, or this with a twist worked for me. So people actually go to this thing, and it's become a bit of a snowball where we seeded it and we're active on it every day, but this thing is taking a life of its own.
I mean, you have thousands of visitors.
Yeah.
On that site, you have wonderful discussion. It has become, as they say, a marketplace of ideas. And I absolutely love what's happening there. And, we'll continue to feed it. We'll continue to grow it. But that's been very exciting.
Yeah, it's really cool. Anyway.
So back to the show, I suppose.
Yeah.
All right. So, Marty, you want to take the lead on what we're spearheading today? Because this is part of the Revisited series.
Yes. One thing that is interesting about HOA disputes is I've come to realize, just after talking with, being around a bunch of HOA attorneys and client services and on the entire team, is that often this is their first rodeo. This is their first time ever being involved in any sort of like legal issue, or they got to the point where it's been multiple years and they're at their last rope and they finally need some sort of legal intervention. They need a higher, degree of assistance.
Which, for better or worse, I mean, listen, if you can live your whole life without ever using a lawyer, that's a good thing. That's not a bad thing necessarily.
It's like living your life without making an insurance claim. I think you've done okay.
Yeah, but all of a sudden you find yourself where it almost becomes this unavoidable reality.
Yeah.
The HOA has dug in their heels. They're not moving. They've stonewalled you for all the variety of reasons we've identified historically.
Yeah, they're a bad HOA.
Right. And, you have a homeowner where often the first reaction is, I'm fed up. I'm sick of this bad HOA. I want to sue. I want to file a lawsuit.
Yeah.
That's the knee-jerk reaction, which I understand. A lot of it is, you kind of, what do you hear about lawyers? They sue. They go to court.
Yeah. I mean, as a non-lawyer and one that has not been sued very many times, but it's you don't know what you don't know. And all we have is the context of books, TV shows, and the media at large, right? When I need to bring in a lawyer, I think courtroom, I think a judge or jury. That's the immediate knee-jerk reaction that I see. And I think that's the misconception. I think a lot of people on the other side of this are thinking, I need to sue my HOA.
And that's the only way to get justice or to solve the problem at hand.
Right. But which isn't the case necessarily.
Right. And that's the episode. That's the nature of this episode.
Yeah.
Is really looking at what we consider and what we call is pre-litigation.
Yes.
It's really before a lawsuit is filed. What does that look like? What are the considerations? And, the real goal, I suppose, is having homeowners think of this in more of a multidimensional sort of way, right? It's not just all or nothing. It's not, hey, I have a bad HOA, therefore I have to sue. There are other alternatives outside of a lawsuit. Because, lawsuits, they're very expensive.
Yeah.
They're long. I mean, there's a lot of, sometimes you have no other alternative but to hit the nuclear button, which is a lawsuit, right? Because your hand is often forced.
Yeah.
However, before that happens, before you hit that nuclear button, you have what's called pre-litigation.
Yeah.
So today, what I'd like to do is sort of break that down.
Yes.
And really simplify it, make it user-friendly so that anyone watching the show sort of understands, okay, it's not just litigation. I have a variety of tools in this toolbox.
And correct me if I'm wrong, the majority of cases that you see, the majority don't make it to litigation.
Correct. The majority actually start in pre-litigation.
Yeah.
And so,
do they conclude in that space as well?
Assuming they settle.
Right.
Yeah. So I would say the vast majority actually resolve before they get to litigation.
Yeah.
And the ones where you just have a absolutely unreasonable board that has just, refused to negotiate in good faith, that's when you have to consider whether or not litigation makes sense after you sort of exhausted the pre-litigation steps.
I think that's the big reveal here, is that so many will resolve before a lawsuit is ever filed. And the second part of that is you have exhausted those other options before you've gotten to the lawsuit, and we will explain why and maybe what those mechanisms are. So yes, there's your open.
Yeah. So let's start with just pre-litigation in general. I think you can put it in 3 boxes initially. One is really that homeowner-driven strategy where it's the homeowner demanding informal dispute resolution.
Okay.
Because, in a very technical sense, and again, this is California, this is under Davis-Stirling, this is a right a homeowner has, but when they have a grievance with an HOA, they have a right to demand informal dispute resolution, which is a way to informally resolve a dispute before it gets to that litigation phase.
Interesting.
Right? So it's almost like this precursor step. There's good reasons as to why you would do it and as to why you wouldn't do it.
Let's talk about real quick too about the nature of that too. Why was that ever put into place? Why was that an option in
What's
the first
the spirit?
place? Yeah, what's the spirit of that?
The spirit, as I see it, is homeowner. At the end of the day, the board is made up of homeowners, and it's a homeowner to homeowner dispute in that sense. This is a community. There's a dispute that's arisen, and IDR becomes this platform where homeowners can sit together, discuss a dispute really outside of courts, and more often than not, outside of an actual lawyer being present. So when it works out wonderfully. You have the board on one side, you have the homeowner on the other side, they're exchanging information. And often when it works, it typically is because there's some sort of disconnect with respect to information. And once the parties sit together and the homeowner says, well, here's why, you're obligated to do A, B, and C. Here's our expert report. Here's what we're actually asking for. If the other side is reasonable and they're actually listening to what the homeowner has to say and the homeowner actually has a reasonable point, things get done. Solutions happen. Resolutions happen at IDR.
So in other words, you think that this provision was put into place because the courts realized that, the drafters of this realize that so many disputes can be resolved because there's a misunderstanding. If you just get 2 people and you get people in the room, reasonable heads will typically solve the issue.
Yeah, it's to foster really early negotiations.
Okay.
Because that's what it is.
Yep.
It's negotiation.
Yep.
Outside of having to bring in counsel, it's just this sort of platform that is, again, it's informal by nature.
Which I actually like, because the people that put the drafters of that, I think, figured out too, there is an economic factor when it comes to bringing on an attorney. And if you could just get it resolved outside that's a big win. Right.
Now, it does presuppose, or it assumes, right, that the other side is reasonable.
Yeah, when we're talking about this, the show is called Bad HOA.
Yeah, and so, I've seen situations where, homeowners go into this IDR, well-papered, very reasonable, and they go into a buzzsaw because the other side is just ruthless, they're unreasonable, they're not listening to anything that the homeowner has to say.
But that could play to your advantage too.
Of course. Yeah. Subsequent down the road, that could be used as sort of this, hey, look at how unreasonable they were at IDR. We were trying to work this thing out. It becomes part of this narrative, potentially of bad faith.
Yeah.
But, what I tell homeowners is if you're ever in a situation where IDR just is not working and it is clear that it's going to fail, just pull the ripcord. You don't have to subject yourself to a tyrant or this really bad, toxic, quote unquote, meeting, if it's not going anywhere.
Yeah.
So that's really IDR. And we've done episodes before on IDR.
Yeah.
I don't want to spend too much time on it.
Yep.
So moving outside of IDR, when IDR is either not a viable option or it's ultimately failed, really the next step, potentially, if you were to hire a lawyer, right? You met with a lawyer. There's really 2 options as I see it, at least in the pre-litigation context.
Okay.
One is a demand letter.
Okay.
You hire a lawyer. The lawyer prepares a robust demand letter, sophisticated demand letter, sends it to the association. Okay.
Do you send it to the association or the association's attorney or both?
Well, it depends, right? You
The famous lines of an attorney.
You should send it to the agent for service of process.
Okay.
Assuming they have an agent for service of process.
Okay. Understood.
So, it's when I say you send it to the association, it could be through that agent. If the attorney is known, you send it directly to the attorney. If it's unknown, it's in the letter itself. Typically, you say, please, forward this to your attorney. Because sometimes the attorney is unknown. We don't know who the attorney is. Now, when I say agent for service, that's typically denoted on the Secretary of State website. So every association is an entity. Every entity should have an agent for service listed.
Understood. Interesting. Learn something new every day.
So
okay,
you send it to the agent. And so that letter goes out. What you have to be careful with, though, with demand letters, and I've seen this throughout the industry, is even if the letter is well written, well drafted, and sort of lays out the law and lays out the client's position very well, if you get an attorney who receives it, reads it, and is operating in bad faith, it could become sort of this endless negotiation loop. And what I mean by that is, the attorney fires it off, the attorney gets on the phone with your attorney, and the association attorney says, hey, I've read your email. Your demand letter. Very, very impressive. I need more information. Send me some case law. And next thing you know, your attorney sends some more case law or sends some pictures about the
They ask for case law? That's such a random...
Well, the point is, I'm not saying exactly what they ask for.
Sure.
They can ask for anything, right?
Yeah,
It doesn't matter what they ask for. But really what they're doing is they're stringing along your attorney, or they're trying to.
There's some gamesmanship 100%.
Happening. It's in bad faith. There's a bad faith negotiation happening. So you got to be very mindful as a lawyer as to whether or not the information that they're asking for or the delays that they're creating are legitimate. Now, there might be an attorney who's legitimately asking for more information. It could be in good faith.
Yeah.
But you have to be very mindful, because ultimately what they're trying to do, or some of these attorneys are trying to do, is draw the dispute out, force the homeowner to pay more money in sort of negotiations that ultimately end nowhere. Right? Because at the end of the day, if it's, you send the letter, but now it's 6 months out, you spent, tens of thousands of dollars on these negotiations and back and forth, and the homeowner association eventually says, hey, you know what? Kick rocks, we're not going to settle. You just blew a bunch of time and money very quickly. Or not very quickly, but over sort of useless informal negotiations.
Right. I think this is a good little button to put on this point, that when the other attorney is present, you should probably bring in your own. Because if you think about it, if they're doing that to an attorney, we've talked about this before. If the other side brings in an attorney, probably best to get your own, because of gamesmanship like this, that they're willing to try to dangle in front of the other attorney. They're trying to game the other attorney to draw it out. Imagine what they're going to do to a non-attorney.
Oh yeah, and we see this all the time.
Right.
You see, cases get handed over to us when decent attorneys, these are good real estate attorneys, they're seasoned, but at the end of the day, they didn't understand how this industry can operate.
Yep.
And so while this, the pedigree looks good on this real estate attorney, they're going back and forth, believing the other side is operating in good faith, but at the whole thing was just all in bad faith.
Yeah.
But very hard to read unless you really understand how these association attorneys can operate.
Right. Yeah. Important if they bring on, because the other thing that I'm thinking about too is if they bring on that attorney, the attorney, if they're trying to gamesmanship this thing, they're trying to paint you into a box.
They could be. They could be doing a lot of things, right? They could be trying to delay. They could be trying to
force you to sign something.
Exactly. Yeah. So just be very careful with the other side.
Yep.
And so that's, sort of the demand letter. When demand letters work, though, they work marvelously, because it's, assuming you have an adult on the other side, a good lawyer, a reasonable attorney representing the association, and they do exist. Yeah. You fire off a demand letter. Maybe it's the case that the association attorney never really understood what was going on until it was laid out in the letter.
Never was alerted of the problem in the first place.
Or the details. There could be a variety of things. But, I've seen good attorneys step in on the other side, say, oh my God, I had no idea this was happening. And a resolution is reached pretty quickly. So demand letters, when they work, they can work well. But I always, say use them with caution.
Yeah.
Understand that they might not be received in good faith.
I think it's another important distinction is to clarify that I've seen this show up in Reddit quite a bit, that the homeowner tries to get a hold of the attorney, the homeowner's, the HOA's attorney directly, thinking that you work for us, right?
Yeah.
When that's not the case. They are not necessarily your friend. They work for the board.
Well, they work for the entity, right?
They work for the entity. Yeah.
Their client is that entity.
Right.
They have a fiduciary to the entity.
Right.
So they're there trying to protect or to, they represent the entity, not the individual homeowners.
Right.
So yeah, you just got to be very careful.
Yeah.
In those waters.
Yep. So the demand letter, when they work really well. That's not always the case. But that's kind of like that's the first shot fired is right there.
And sometimes they work well in terms of gathering additional information. You fire off a demand letter, and you might be able to test the waters on the other side. When this firm fires off a demand letter, and we immediately see a response which clearly indicates that they're not negotiating with us in good faith. I mean, we'll pivot very quickly. We're not going to waste time and money negotiating with a wall. You know what I mean?
Yeah.
So, but you also get a sense of who you're dealing with. So it could be good intel. I mean, there's a variety of reasons why you send a demand letter first before what I would consider really the next step or the next weapon in your arsenal, which would be a demand for alternative dispute resolution or a demand for ADR, which is a different type of demand.
Okay.
The demand letter exists as just that. It's a demand. It typically lays out the facts, the law, and some sort of resolution. The ADR demand is different because in the ADR demand, you're actually demanding that the association attend mediation. And this is under the Davis-Stirling Act. So what you're doing is you're triggering an obligation with your demand letter, which is not litigation, and saying, a certain dispute has arisen. Here are the specific potential causes of action, or here are what's wrong with the association.
Mm-hmm.
Before we file a lawsuit, we are demanding ADR under Davis-Stirling. Very powerful tool. Okay,
so when you send that off, what are the triggers? What is it? The wheels are in motion for what?
Upon receipt. So once the association or the association's attorney receives it, by law, they have 30 days to respond.
What is that response? Say yes, no, kick rocks?
So it's either yes, we'll go to mediation, 2, kick rocks, 3, they just don't respond at all. They ignore it. All 3 are possible, right?
Yeah.
Vast majority will accept. Because if they don't, it becomes very sort of tricky for the association, right? If they reject the mediation or the demand for mediation, or they ignore it, what they could do is potentially waive attorney's fees should that homeowner then bring their lawsuit.
Interesting. Okay. So that's within the Davis-Stirling Act.
Yeah. So what you're doing is you're sort of triggering this obligation on behalf of the association to mediate in good faith. If they refuse to do so, 2 things could happen. 1, the homeowner then could move forward with their lawsuit. And the homeowner, by demanding ADR pursuant to Davis-Stirling, they preserve the right to attorney's fees. And the association may very well have waived any right they would have otherwise had to attorney's fees. You see what I'm saying? And that's sort of the danger if an association rejects that demand for ADR, which makes the ADR demand a very powerful demand.
Interesting. So without that demand, you may have waived your right to attorney's fees.
Right. So that also, look at it from a homeowner's perspective. And I've also seen this. They send out, they hire a real estate attorney, more of a generalist. That attorney fires off a demand letter. Hey, we're going to sue if you don't do A, B, and C, negotiate. Association comes in, says, we're not going to negotiate. Lawsuit is then filed. They skip the ADR step. And we've been in situations before where we've gotten the file and we've actually had to dismiss the lawsuit, and we've had to go back to that ADR phase.
Oh, because you
wanted to preserve your right to attorney's fees. And it gets kind of complicated procedurally how you do that. But, the point is, if you are going to file a lawsuit, and a lot of our clients come in ready to file a lawsuit,
right?
You have to make certain that the Davis-Stirling Act doesn't require ADR first. And more often than not, it does. it does require mediation to happen before, or at least a demand for ADR.
A demand for it.
Before you file your lawsuit.
Because they could say kick rocks, and you said, well, I still did what I was required to do, and therefore I've preserved my rights to attorney's fees.
Yes, and you can be in a very dangerous situation. Let's say you're a homeowner, you skip the step, you file your lawsuit, and you prosecute the lawsuit all the way to the bitter end, and you prevail. Okay, you win the lawsuit. What's going to happen is after you prevail, the judge will say, at this point, feel free to file your motion for attorney's fees, because you're often going to seek attorney's fees, right?
Yeah.
You want your attorney's fees back. You'll file your motion for attorney's fees. The judge will review it, and the judge won't see a certificate of mediation, meaning there was no sort of ADR step that was followed, because after you go through the mediation process, you get a certificate of mediation to show that you've complied with that ADR prerequisite to secure those attorney's fees. So without that certificate of mediation, the judge is not likely going to award attorney's fees. It's going to be a serious disadvantage of you winning attorney's fees.
Which is just a bummer all around, obviously.
So basically, long story short, the ADR demand becomes very powerful going through the process. There's a lot of upside to it. In addition to the fact that, going through the mediation process, if you can settle, that's a big win unto itself to avoid that lawsuit in the first place.
Because as we mentioned before, lawsuits can drag on.
They can be expensive. There's a lot to them,
Yeah, there's multiple compelling reasons to not and to try to get it taken care of prior to that.
Yes,
that point.
Exactly.
Okay, assuming that the HOA complies and says, yes, we'll move forward with your ADR demand. And I assume that this is when mediation comes into play. Yeah.
And really the trick here is once a demand for ADR is issued, you have 30 days really until, the HOA has 30 days to respond.
Okay.
Sometimes they'll respond within a handful of days. Sometimes they'll wait till day 29. Sometimes they'll say, hey, can we get a quick extension? There's a variety, but at some point, the vast majority of associations, good, decent ones, or ones that are at least trying to protect their interests, will agree. At that point, really the strategy is to get that mediation scheduled ASAP. You want to get it on the books, because another tactic of these association lawyers is that they will kick the can and try to avoid the mediation. A lot of associations that we're dealing with are often in the wrong, right? So they're trying to avoid being pulled into the principal's office. Right? I mean, that's
it's
sort
just
of
prolonging the inevitable.
maybe. And there is a requisite time where these things are supposed to be mediated. You have 90 days to actually get the dispute on the books. And of course, there could be extension by way of mutual agreement, but generally, you want to get it on the books ASAP. That means select a mediator, select a time, a date, and get the parties at the mediation.
Okay. So can we really quick just define the difference between a mediation and arbitration? And is there a difference in this context? Is it when ADR is always, will some result in arbitration, or is that kind of like door number 3, where we tried to go through door number 1 and didn't work out, so now we're trying door number 3?
Yeah, think of arbitration as it's an adjudication. There's an actual decision being rendered, okay? Mediation is a negotiation. So, mediation, it's not a win or lose proposition. If you go to a mediation, even if the mediator comes in, who's often a retired judge or a seasoned lawyer, if that mediator says to you, hey, you have a slam dunk case, you will win 10 times out of 10, all the facts are on point, your law is on point, what you're asking for is well within what the law can provide, that mediator cannot force the other side to settle. So even if the mediator,
and that the same logic applies to you.
The inverse is also true.
Yeah,
but that mediator cannot force any sort of outcome. It has to be negotiated and agreed to by both parties, which is different than arbitration. Arbitration, an arbitrator actually says you win, you lose. Right? There's a decision, or like I said, an adjudication.
Is that legally binding the arbitration?
Well, I don't want to get too technical on
Okay.
arbitration. You can actually, there's binding arbitration and there's non-binding arbitration.
Okay, there's a winner. There's a winner and loser. Legal means that it's binding. It must.
It's enforceable.
It's enforceable. Non-binding means that it's not enforceable. This is just how we see it.
Correct. There's a decision.
And then the HOA can still say, "Oh, kick rocks. I'm going to go to."
Then there's a whole process,
Yeah.
right? But if you go to the arbitration and you prevail and it's binding, you take the arbitration award, you get it stamped by the court, and now it's enforceable. So, but that's not mediation. And you also have to realize in arbitration, I mean, that's a mini trial.
Sure.
There's discovery. It serves as sort of this privatized court system, and it's completely different than mediation.
Okay.
In the mediation context, in the association, I guess, mediation context, we have the right to demand certain documents by way of 5200, Civil Code 5200. That gets us certain access to certain documents, but we don't have the full discovery mechanism, right? We can't demand depositions or demand documents at that point, other than maybe, the 5200 code section. But
because at the end of the day, this is informal. We're just
much more informal.
We're trying to get an adult in the room to hear both sides and facilitate a resolution.
Correct. That is the outcome, or that's the outcome that we're looking for at a mediation.
Yeah.
Now, what's the question always comes up? What's the format of the mediation?
Sure.
What does that look like? Right. So California, I'm talking about California. Florida is actually a little bit different. We can have Jeff on the show to talk about Florida. But often, if it's in person, you're in one room with your lawyer. The association is in their room with their lawyer, and it's the mediator bouncing back and forth trying to get a resolution. That's really what it.
Getting their steps in.
They get their steps in, And now, of course, a lot of them are by way of Zoom, so it's they're just going to different rooms virtually. But before the mediation, you'll submit a mediation brief. Sometimes it's confidential, sometimes it's not confidential. There's reasons for both, I suppose. But you submit the brief, and you are there negotiating. And the mediator, their job is really to facilitate a resolution. And what's interesting about mediators is they have different approaches to mediating.
Oh, interesting.
There's different styles of mediators.
Yeah.
I would say some are very transparent and will say, I truly believe you have a good case. Here's why. Let me go try to, put pressure on the other side. Other mediators play it differently. They go into the association's room and they say, you have no case. Homeowner's going to smoke you. You're cooked. There's no way you're going to win. Okay.
Yeah.
Then they go to your room, the homeowner side, and they say the exact same thing. They say, hey, the association is going to win. You, the homeowner, have no case. And they kind of drive sort of by way of fear resolution. So there's different tactics that even mediators use, for better or worse.
Do both sides have to agree to the mediator?
Yes.
Okay.
Yeah, and there's a sort of a process that happens. There's a mediator selection process. And, there's a lot of good mediators in California. From what I've been told, there's a lot of phenomenal mediators in Florida as well. So yeah, it goes through sort of a process, but eventually you select one, and that's the format. And if you're seeking economic damages, there's a number that's kind of going back and forth. If it's non-monetary relief you're seeking, maybe you want the association to fix some sort of common area element. Maybe it's the roof. We talk about the roof a lot.
Yeah.
So it could be a number of things, but those become the negotiation at the mediation. And the mediator's job is really to take the information, take the arguments, and present them. And there's sort of this back and forth, push and pull. And if it settles, the resolution is often by way of a settlement agreement. And, it's a 1542 release, meaning it's a release of all claims as it relates to these specific issues. But at the end of the day, if it settles, the homeowner now has a binding settlement agreement, a contract. So that is a wonderful outcome, because that's a really powerful tool. That's a hammer that they can use moving forward. Meaning, if you're in a settlement negotiation, and let's say the association says, "Hey, we're going to pay your attorney's fees. There's $100,000 in damages that you've incurred, and we are going to fix the common area." Okay. That's reduced in writing. Okay. And let's say the common area needs to be fixed within a certain amount of time. You define it, because we don't want it just to be an open-ended sort of obligation.
Yeah.
If it's not, if it doesn't happen within that amount of time, the homeowner then has the right to sue for breach of the settlement agreement. That's where you could hardline one of these cases directly into court at that point.
And yeah, you don't go back. It's like, okay, we're just going, we're going for
Correct.
it. And we have everything we need in the bag here. I mean, we've got the settlement agreement. It's agreed upon. They, for whatever reason, didn't facilitate it. It's pretty slam dunk at this point.
And a good attorney will put in, obviously, an attorney's fees provision. So should the homeowner have to sue for enforcement of the settlement agreement, upon prevailing, not only will they get the relief sought, but also their attorney's fees for having to bring the action in the first place. So
how many times have you had to go back? I mean, have you had to go back to the well again? Because these settlement agreements are not.
Oh, it's happened.
Yeah.
It's happened. I mean, that's why you put it in writing. I mean, you don't leave a negotiation or a mediation with a handshake deal.
Sure.
That's insane.
Yeah.
Right. So you reduce it in writing, and then it becomes this enforceable instrument thereafter. And that's mediation. I mean, that is pre-litigation. So when we talk about ADR, or alternative dispute resolution, what we're often referring to as mediation. So when we say we're going to send an ADR demand, well, we're demanding mediation under the Davis-Stirling Act. And that is really pre-litigation. And so when we talk about, a homeowner coming in saying they want to sue, I mean, this is part of the analysis. Does it make sense just to jump into a lawsuit? Well, typically it doesn't, for the reasons I identified.
Yeah.
You might waive your right to attorney's fees.
Yep.
So if litigation then is off the table, then you're really looking at sort of maybe potentially going to IDR, informal dispute resolution,
which is just
homeowner-driven.
Homeowner-driven.
And sometimes that makes no sense based upon what I'm seeing in a file. If I see a very bombastic opposition or their attorneys involved, self-help may not make any sense.
Yeah.
Then you're now cutting it down to a demand letter strategy, or you're going straight to ADR. Now, the demand letter might make sense if the other side seems very reasonable, or maybe they have an attorney and we've worked with that attorney before and they're actually, one of the better association attorneys. Not often the case, if I'm being honest, but we might see some opportunity there.
In other words, you can resolve this before mediation even happens.
Before we even send the ADR demand.
You make your demand letter to the two sides get in, two lawyers kind of work it out.
Yeah.
Get it resolved. Done deal. Goodbye.
Yeah, exactly. And like I said, if you're going to hire a lawyer, the demand letter, when it works, it's the best option.
Yeah.
But again, you have to be so careful with them because you don't want them to turn into these endless negotiations. At least with ADR, it's this defined course.
Sure.
Right? They have, when you hit them with the ADR, they have a certain amount of time to respond. You have a certain amount of time to actually get the mediation completed. And if it doesn't settle, you now have a right to move forward with your lawsuit.
Is there some gamesmanships that are played from the other side regarding mediation? My knee-jerk reaction when I hear it is like, why not just drag it on and say, we don't like the way that this is going. We're going to go ahead and
There is. And so if you're a lawyer and you're seeing that, you paper that exceptionally well.
I see.
It's dear so-and-so, you said that you were going to get back to me on a Tuesday. Now Thursday at 5 o'clock, I've yet to hear from you. Please advise, this looks like bad faith. And what you want to do is you want to establish this paper trail of sort of this bad faith gamesmanship.
Just like we've said in nearly all of the podcasts, the lawyer is doing the same thing. This is the tactics. Like you need the paper trail if they're operating in bad faith, and because that's what you guys do here. This is what the actual attorneys do.
And at some point, if you see this conduct of just delay, or being non-responsive, at some point you can identify, hey, this is in bad faith. They have no intent to actually go to mediation. We're going to forego the mediation. We've satisfied our obligation.
Because all you have to do is file or request it.
We request it, and they hit us with a bunch of bad faith sort of responsiveness or lack of responsiveness, right? They're non-responsive. So long as it's papered and we can, truly demonstrate that, hey, this looks like bad faith, we don't have to subject ourselves to that. And at some point, maybe the lawsuit becomes the next viable option.
Do CC&Rs ever dictate the path that you have to take? Like for instance, the CC&Rs might say, Again, this is just purely speculative. That if a dispute comes about, that you must be solved in arbitration.
They could put a forum provision, an arbitration provision in.
Okay.
Yeah, but when we're talking about pre-litigation, I mean that's Davis-Stirling. Now, CC&Rs can mirror the Davis-Stirling Act.
Okay.
Which I've seen before. But yeah, I mean, they could call for arbitration.
So in other words, this goes back to hierarchy, right? The Davis-Stirling says X, your CC&R cannot be in conflict. It says, no, you can. You're saying, I want to go to mediation. We're going to file an ADR request. But the CC&R say, you must go right to arbitration. Well, that's in direct conflict with the Davis-Stirling.
Yeah.
Okay,
and there's some caveats around the association trying to force arbitration as well. I mean, it's not as clear cut as, as just, hey, if it says arbitration, we have to go to arbitration. There's different ways of looking at it, or arguing against it, right?
Yeah.
But that's, it's really looking at the Davis-Stirling Act and understanding that certain things have to happen before you sort of ratchet up to that nuclear option. And if you don't follow it, if you fall outside of it, there could be negative consequences of it. Even though you're really bullish, you want to litigate, you want to move forward in that direction, that's great. But to be, consistent with the Davis-Stirling Act, it's advisable to go through the process. Because if you don't, there could be really bad consequences down the road.
Like we discussed in potentially
waiving
all
of your attorney's fees.
Yeah.
That's a big deal.
Yeah.
Yep. You win, but you kind of don't win in some ways. So that's the world of pre-litigation.
Yeah. Interesting. And like you were saying, the majority at least start there. Like that's the
majority. Sometimes you get cases that we see where our client they were hit with a lawsuit. They're on the defense, right? And that sort of forces our hand into the litigation. But yeah, vast majority of these cases, even if, let's say for some reason the Davis-Stirling doesn't technically require ADR, there might be good economic reasons to start with ADR.
Right. Yeah. Makes sense because lawsuits can go a year and are expensive and emotionally draining.
Yeah. I mean, it's like you don't, if there's other ways to fix, if you're like in the medical space, right? And there's ways to rehab a shoulder without surgery. You may want to look at that first before you start like cutting into the shoulder.
Yeah.
Right?
Yeah.
Same thing here. I mean, if there's better ways, less intrusive ways, more efficient ways to solve the problem, maybe you start there as opposed to, again, going into that very drastic step of litigation.
Well, I just realized too that there's also a win for the association that when a lawsuit's filed, when people are searching for the neighborhood, like you can look up all the lawsuits that's ever been filed against that showing that, man, this association really stinks. It's really bad.
Well, most associations don't like to get sued.
Right.
Sometimes they bring it upon themselves. It's self-inflicted because of the unreasonable position they take. And so they force the homeowner's hand. But, if you can resolve it at the mediation, it's a win for everybody.
Interesting.
Yep.
See, learn something new every time on this show, even me.
All right. So what do we have coming down the pipeline? What can the viewers expect? I know we were kind of shifting back sort of into Grand Vision. We have season 3 coming up.
We have season 3. What's crazy is that we have more merch coming. We sold out again of the merch. Like every time
you go ahead.
Every time that we do a merch drop, that we get more stuff in. I want some. We had a backlog of people that said, "Hey, we're giving this stuff away," and we have more coming. We did another order, and we have a couple new items that are coming as well, which should be fun.
Okay, yeah, I love the merch is making its way out of state. I heard someone recently they were in like New York or they had the merch and they're like, oh my God, I should have grabbed a photo.
Yeah. I mean, I love seeing the merch. We get pictures sent to us every once in a while. We should put it out there.
I think so.
Next time we'll throw it up on the Instagram. But seeing the Empowered Homeowner sweatshirt on just anywhere outside of our little circle still blows my mind. Like it is when we see people that have watched the podcast and saw their enjoyed disputes.
I love the stories where they wear it to a board meeting or even to like some of these IDRs.
Oh, the tote was such a the tote was such a little provocative move.
It's a power move. Is what it is.
We walk in with the tote, with all of your evidence to some of these meetings. It's really great.
Yeah. So more merch is coming down the pipeline. Season 3. Get ready for that.
Yeah. And then we have a few more episodes before season 3 starts as well. We've got so many fun things and some interesting stuff coming down the line. So I'm excited. There's a lot of fun stuff coming.
Well, thank you, Marty.
Thank you. It's been fun. Always learning something.
Thank you guys for watching. Again, like, subscribe, go to our Reddit community. It's just, what do the kids say? Poppin', bustin'.
I love that community so much because the amount of just help there and seeing that community thrive really brings me a lot of joy. And I love being a part of that community, to be able to like interject and throw stuff out there and share our empowerment kits and give away like books. We've given away lots of like books to people that have asked for it. Say, hey, can I get a book? We've definitely given away books. Speaking of the book, I mean, that thing still is in its segment is still a bestseller. So again, kudos to you.
All 3 categories. Well, I think, again, it shows the need of the book. It was so well received. We took first place bestseller for real property law.
Yeah, there were several categories that we were number 1 in and remain as well. So there just shows that there was such a need, and when we saw that need early, and just tried to fill that void, but that the book still is selling well. The audiobook is done really, really well. The audiobook's great. Kudos to you. Read by you as well. I know that was fun to witness.
Well, yeah, that was quite the project. But I like the idea that people can get empowered with on their drive to work. That was sort of like, how do we make this information as accessible as possible? How can we make it just very user friendly? If you don't have time to sit down and read a book, you have the Kindle version, then you have the audio version. So again, it's accessibility, and we're going to continue to produce great content.
There is some fun content, collaborative content, just from some stuff that we can't get into.
You're going into 2027.
It's already in progress, but there are some really exciting things that we can't. You will know in time.
Yes.
But I'm so excited about it. Some of the stuff that we're working on with just some phenomenal people as well. So I can't wait. I can't wait for that too. It's already in motion. So this, as much as you think it's been a hiatus for us to get our beauty rest, it's actually been to there's some really cool things that have been on the horizon. So anyway, we'll leave it at that.
All right, Marty. Well, thank you again. And thank you guys for watching. Until next time, we'll see you soon.